Greetings to Madam and my fellow friends. We are from Group 6. My name is Lim Kai Yi, metric number 264795, and I'm going to explain about the brief facts of the case. Abdul Aziz bin Atan and 87 others versus Ladang Rengo Malay Estate Sendirian Berhad. Ladang Rengo Malay Estate Sendirian Berhad, the respondent, was a company owned by 25 shareholders. There was a piece of land which carrying business of rubber estate and oil palm registered under the company. On 10th March 1981, the shareholders sold their shares to Gemas Baru Estate Sendirian Berhad through a written agreement. Clause 11 of the agreement highlighted three main things, which are: firstly, the vendor shall carry out the affairs and management of the company in a similar manners as the past. Secondly, not to unreasonable or excessive tapping the rubber trees or oil palm of the company. And lastly, the vendor shall provide the purchaser a complete list of trade liabilities incurred since the date of agreement, and the vendors shall declare the balance of debt owed to the creditors shall not exceed 50,000, and the vendor shall pay exceeded amounts, providing that no contingent liability has arisen by reason of any guarantee given by the company. On 3rd of November 1982, Abdul Aziz and 87 other employees filed a case against the company on the ground that the sale took place without notice to the employees, although there had been a change in the manager and staff. The inquiry officer gave a decision that the complainants were never terminated, thus they appealed.
Assalamualaikum warahmatullahi wabarakatuh, and good morning. My name is Nadhirah Amir Hussein, and I'm going to present issue of the case and also argument that made by the appellant and also the respondent. The issue that arises in this case is that whether there is changes of employer since the shareholders have sold the assets to a new purchaser. The second issue of this case is whether the employment contract will be terminated and cancelled since there is changes of ownership of the company. The appellant argued that the Regulation 8 of employment contract shall be terminated since there is changes of shareholders and ownership of the company. He submitted that in the said argument, it stated that it deemed to be terminated when there is a change. The appellant claimed that there is a changes of ownership of the company because the previous shareholders has sold the assets to a new buyer. As a result, the employment contract shall be terminated. Therefore, they are entitled for amount of money because of termination benefit. The appellant added that the business or assets of the company is not belong to the company, but it's owned and belong to the shareholders. It is because they are the one who buy and hold the assets, meaning to say that the shareholders are the owner of the company, and thus the act of selling the shares are regarded as changes of ownership of the company. When there is a changes of ownership, then there is effect to the agreement, policy and also contract that has made before the shareholders sold to a new buyer. Next, we move on to the argument they made by the respondent. On the side of respondent, he argued that there is no changes of ownership of company or changes of employer of the company. The shareholders are not the owner of the company because they have no right over all of the assets of the company. An incorporated company is a legal entity separate and distinct from its shareholders. So the company has a perpetual succession, which means there may be a changes of employees or shareholders of the company, but the existence of the company will be remain the same as before. Even though the members of the company come and go, but the company will be continued and regarded as the same as before. There will be no changes to the company. As we know, the main characteristic of company is that it did not change its personality and also identity, and it will be remain the same even though there is a changes of shareholders, as in this case the previous shareholders sold to a new purchaser. Therefore, the claim of money made by the appellant shall not be granted by the court because there is no changes of ownership of the company, and employment contract shall not be terminated, as it will be continued as same as before. Even though the shareholders sold the assets to another purchaser or buyer, it does not give effect to the existence of the company. Therefore, the employment contract will be continued and regarded as not terminated. That's all from me. I will pass the presentation to the next presenter.
Assalamualaikum warahmatullahi and a very good day to Doctor. This is Farhah Kamal and I will provide the judgment. The court in this case dismissed the appeal of the applicants, declaring that an incorporated company is a legal person, separate and distinct from the shareholders. This actually relates directly to the principle established in the Lemma Solomon and Company Limited in 1897. Consequently, the company will continue owning all the assets of the estate that were an integral part of the business for the purposes for which the applicants, Abdul, Aziz, and 87 others were employed. The company did not change its identity or personality, and hence there was no change whatsoever in the constitution of the respondent company due to the purchase. This verdict is actually similar to Cameron and Hector Finlayson and Company Limited, 1967. In this English case, although the share capital of the company was acquired by another firm, the company still survived and carried on its business. No legal change against the company business shall be made, and so the applicant also remained in its employment after the sale of the shares. In the recent Zamri bin Arshad and 20 others and MISC Integrated Logistics Syndrome Berhad 2018, Lin Chong Fong judge also held that the change in shareholding of the company will not constitute a change in business. That's all from me. Now we move on to the principle of law.
Hi everyone, my name is Ong Lay Xuan. My entry number is 262639. Now I'm going to talk about the principle of law. According to Regulation 8 of the Employment, Termination and Lack of Benefits, Regulation 1980, when a change of business ownership for the purpose of which an employee is employed or of part of such business occur, an employee shall not entitle to termination benefits if within 7 days of the change of ownership, the new employer offered to continue to employ the employee under terms and conditions which are not less favorable than those under which he was currently employed, and he unreasonably reject the offer. Therefore, the employee would not be entitled to termination benefits if there is no material change in the ownership of business. So, what is the meaning of change in ownership of the business? A change of ownership is said to have taken place when there is a transaction of actual trappings of the business as a going concern and acts as an automatic termination of employment. An actual change of ownership situation would involve more than the merely transfer of the assets. What must change hence are the components of business such as physical assets, intangible assets, customer, work in progress, or existing contract. Therefore, a merely transaction of business share is not considered as a change in the ownership of a business. In this case, the court takes into consideration the principle of separate legal entity. Under the Companies Act 1965, it provides that an incorporated company is a corporation that has a separate legal entity. In other words, the law would treat the company as an artificial legal person which exists independently from its member. It can be sued or be sued in its name, hold the property, and carry out the operation of a business by itself. This concept allowed limited liabilities to the shareholders since the company is liable for debt incurred, but not the shareholders. The shareholders own the right to sell or transfer their own share. However, they are not entitled in handling the company's property or assets. The previous shareholder of the company who is disposing of his share in the company will enter into the share sale agreement with the new purchaser who will become the new shareholder of the target company. As a company is, in the eyes of law, considered as a separate legal person, the business of the company will remain with the company notwithstanding the change of ownership at the shareholder level. According to Section 16 Clause 5 of the Companies Act, it provides that a corporation will still be considered as continuance despite the occurrence of death, bankruptcy, change in membership, or transfer of store. It means that a limited company has perpetual succession until its termination or dissolution by the shareholder. Therefore, the ownership still remains with Ladang Rengo Malay Estate Sdn Bhd even though the shareholders transfer their whole share to a certain buyer because the company is regarded as a separate legal entity. Besides that, Ladang Rengo Malay Estate Sdn Bhd will still continue to carry out the same nature of the business for the purpose for which the employees were employed, and the employees also continue their service without any termination of employment contract. In other words, as Ladang Rengo Malay Estate Sdn Bhd still continue to own the assets, the court considered there were no changes in the ownership of business.
My name is Pei Qi, metric number is 264527. Now I would like to further discuss about the analysis part. According to company law, an incorporated company is a legal person that's separate and distinct from the shareholders of the company. It has the capacity to contract and incur legal obligations. From the date of incorporation, the company has perpetual successions and will continue to exist even if there is a change of memberships. The Company Act also provides that the liability on the part of the shareholders to contribute the assets of the company will be limited to the amount of shares that they have been taken up but not paid for. So the whole point of forming a limited company is that the shareholders can control the management of the business without incurring the risk of being under unlimited liability for the debts of the company. In this case, in order to succeed in appealing, Mr. Lobo should prove the elementary concept of company, which is the constitutions of the company of Ladang Rengo Malay Estate Sdn Bhd had changed its legal identity or legal personality, and it had no longer to continue to own all the assets of estate, which were an integral part of the business for the purpose of which the applicants were employed. In the case of Kumpulan Company Sdn Bhd versus Raju, it clearly distinguishable on the facts. The divisions of the appellant company was sold to the National Land Finance Cooperative Society Limited. In this case, it did not deal with the sale of shares but a sale by the company of a part of its operations which thereby passed into new hands. As a result, from the date of the handover, the terminations of the service contracts of the appellant company's employees affected by the sale with effect. Furthermore, referring to the case of associations, Motor Industry Sdn Bhd versus Tanggaraju, the appellant limited company in the business of the assembly motor vehicles at Shah Alam had all its shares owned initially by Wian Brothers. Wian Brothers then sold out to the Ford Motor Company. Tanggaraju contended that the takeover amounted to a change in the ownerships of the business, and Abdul agreed. Where in this current case that we are discussing, reading of regulations A does not support the construction Mr. Lobo sought to place upon it. The proposition Mr. Lobo at once had violated the most elementary concept of company law. A single shareholder of company only owns the shares in his name. He has no right to lay his hand on the assets of the company. In certain circumstances, it is of course shareholders have power to win up a company and have the net assets thereof. However, it only distributed to themselves after satisfaction of all its liability. But until that happens, Property standing in the name of company belongs to the company. Thus, in this case, it only deals with the sales of shares. The claim for terminations, benefits under Regulations 8 was dismissed. The ownerships of the business never passed into new hands. Hence, terminations of contracts of the company was not affected. This is because there is no change whatsoever in the constitutions of the respondent's company. The company remains its legal identity and personality and continues to own all its assets although there is a change in membership. In short, Mr. Lobo failed to prove that the company has changed its legal personality. The worst change within Regulations 8 was looking to the company but not the change regarding the identity of the shareholders. In other words, the business of Ladang Rengo Malay Estate Sendirian Berhad was not owned by the shareholders but by the company. Thus, there is no change in the ownerships of the business, even though the said shares has changed hands here, but the fact remains that the company is still the owner of the estate.